Welcome everyone to this new episode of the Privacy Rules Privacy Espresso series, a series where we interview our experts from all over the world on the latest news on privacy, data protection, and cybersecurity. Today we are going to speak of a very recent news that is the first ever fine from the Brazilian Data Protection Authority in Brazil that has been issued on the 6th of July. And we are going to discuss about it with our expert from Brazil, that is Luiza Sato from the law firm TozziniFreire Advogados. So Luiza, first of all, thanks a lot for being with us today.
It is a pleasure. Thank you for having me again, Alessandro.
A pleasure as always, Luiza. Well, let's go, into the details of the case. So why don't you start by giving us a brief description of what happened and which is the decision about?
Of course. This is a very big deal here in Brazil for us. We're all expecting this. This very first sanction from our DPA, which is ANPD, is how we name our DPA. And everybody was expecting just to see how the authority thinks. So what happened was the LGPD became effective in 2020, September actually. And then just after that, early 2021, the Public Prosecutor's Office of the state of São Paulo, my state, reported to the ANPD a weird activity, or so they thought, that there was this company called Telekall Infoservice that was offering services to companies, actually to political candidates, because we were at the time of the elections. They were offering these WhatsApp numbers from voters, from possible voters, so that they could explore this database in their political campaigns. So after that, the ANPD tried to contact the representative from this company several times, but receiving no answers. After all the investigations, the ANPD verified that this company, Telekall, offered lists of names, WhatsApp numbers, physical addresses in Excel formats to many companies, and they were announcing a database composed of over 130 million individuals, so lots and lots of data subjects. And then after this, a formal administrative proceeding was started by the ANPD, and just after that, a representative from this company showed up, presented its defense, but it was considered super insufficient by the authority. So the violations after the proceeding was completed were that the company did not rely on any lawful basis for this processing activity, and for this violation, the fine was 7,200 reais, which is around 1,300 euro. The second violation was not appointing a DPO. So for this, just the sanction of a warning was applied, not a fine. And the third violation was not presenting to the authority the requested documents, namely the DPIA and the ROPA, the records of processing activities. And for this violation, the fine was also 7,200 reais, approximately 13 euro.
Okay, perfect. Thanks a lot. And the first thing that I notice is that the fine is not very high. And this is interesting because we have been speaking about, the LGPD and the compliance, and you've always been saying, let's wait when the ANPD will start making fines, because this can be a way for, companies to be pushed to start complying with the regulatory framework. So do you think that such a fine would have this effect of convincing companies on starting, complying with it, or not? What's your opinion on that?
Yeah. When I first read the order that was issued to us before the reasoning, I got really disappointed, because I thought, oh my God, this is too low. No one is going to, fear the LGPD, or we just think that the compliance projects are, not that important because the fine is so low. So this was my first impression. But then the day after, the reasoning was published by the ANPD, and everybody could read it carefully. And you know what? Under our LGPD, we had that 15 million reais fine, and that everybody was, expecting something like this to come up. But the fine is actually 2% of the annual revenue of the company, limited to 50 million reais. And in this case, this offender, Telekall, was a very small business, and the 7,200 reais was actually the top fine, the 2% of their annual revenue. So in this very first sanction, the ANPD already applied the maximum possible fine. So I believe that this could be understood by the processing agents as a very good sign that they should care about their compliance with the LGPD, because the ANPD has already started its sanctioning activities, and it's not plain easy.
Yeah, no, that makes total sense. And of course, there is also, the value of those decisions, because the more you will receive, the more you will understand how the ANPD, is interpreting the law and is requiring companies to, address it and to be compliant with it. So there is also the fact that in many cases, the first fines are also some sort of guidelines for companies. So it makes sense that, company and authorities have an approach that is constructive and indicates what should have been done in that specific case. That being said, Luiza, which are basically the key takeaways that this leading case bring in particular to, I would say, data processing agents subject to the LGPD, the Brazilian regulation?
Perfect. I would name 4 main takeaways that I can think of. The first one was that it is interesting to see that this case was not started by the authority itself or by an angry data subject. It was nothing like that, but actually it was started by the public prosecutor's office. So it means that we should know that other authorities are actually concerned about this matter. So this is the first very relevant takeaway. The second one was that everybody was kind of expecting that the first sanctions would be educative only, like warnings or instructions, but not of a punitive nature. But this was not what happened. The authorities already issuing fines, and as I said, could be considered not really light ones. A third one would be that the offender was punished because of violations that could be easily avoided just by performing simple tasks under a data protection compliance project, like appointing a DPO, which is really basic, maintaining the records of processing activities, also really basic, preparing a DPIA, which is a data protection impact assessment, and relying on a lawful basis. This is like the most basic task of all, to perform personal data processing activities. And then the last one, I would say that, this report that I said, published by the authority, was made available to everyone, not only to data protection professionals, but to the public in general. So this means that everybody in the whole world can read it. Of course, if they understand Portuguese, they would understand it better. And the document has really became viral in Brazil. So this may be even worse than actually paying a high fine, because the reputation here of the company was deeply affected.
That's very interesting, Luiza. Thanks a lot for all those key takeaways. The first one in particular, I think it's very interesting because in the EU, we are used to, have fines that starts from individuals' request, that is subject request to the authority. So it's very interesting to see that in this case was a public prosecutor, but this may be part, of a processing of awareness also for the people out there to know that, they are now protected. So, public institution starts and give the lead, provide the lead also to individuals. Thanks a lot for all those points. It was extremely constructive, and it's nice to see, that things are really moving in Brazil. So better to start looking at, complying with the regulation if you don't yet. To do that, of course, you can contact us, and in particular Luiza directly if you need any kind of support. Luiza, as always, thanks a lot for being with us today. It's been a pleasure. I would also like to thank our listeners for being with us, and see you with the next Privacy Espresso. Bye, everyone.